have a panel such as this is extremely helpful. So we are very grateful to have your years of experience and your background working in this subject matter here with us today, both your written testimony and what you've shared with us during this hearing. We have a number of us commented, and I think it bears noting again here today, the good work and integrity of so many of the men and women of the FBI who work out in field offices across this country. However, that said, we are of course here to address a very specific and serious concern, which is the misuse of FISA and surveillance techniques. And I believe there's broad agreement here that we have much needed reforms to discuss. I'd like to go back, Mr. Scher, to some of what you've testified about in parts of your written testimony that you submitted to us. So we know that 702 is providing the FBI with access to a large amount of information about Americans. But one thing that you have touched on when we look at the concept of potentially creating alternative statutory schemes or potential revision, the concept that the government is also utilizing other sources of information, private data, other things to essentially surveil or gather information about Americans. I'd like to hear more about that subject and what you would propose, if anything, we should be doing to try to monitor or curtail that practice.
I assume that you're referring to the purchase of data,
yes,
which is, in my view, an equally, if not more serious problem than the vast trove of information that's collected under pursuant to Section 702. And certainly both of those enormous databases together can be an enormously powerful surveillance tool. And like any other surveillance tool, it should be subject, in my view, to a judicial order with a probable cause requirement. I think that's the most important thing that can be done. I don't think any of us here on the panel are disputing the wisdom or the ability of the FBI to collect the underlying data. Yes, in many instances it's broader than it needs to be, but the key event is not so much the collection of the data as the searching of that data using identifiers that are specific to American citizens. In my view, that constitutes a search for Fourth Amendment purposes, and even if you disagree with that, it's still an important event to the privacy of an American citizen, and is therefore something that Congress can and should regulate very closely.
Okay. Thank you, Mr. Scher. Professor Turley, I'd like to go back to something you mentioned earlier as well, and that is the concept of making the FISC court process more adversarial, adding an adversarial component of that or having an amicus involved in that process. Would you elaborate for us on how you think that type of reform could be implemented and how that might look?
Thank you very much for that question. The Congress years ago implemented this amicus process by which the court can reach out by what the Congress described as novel questions to get the assistance of essentially a third-party view, separate from the government. That has been relatively underutilized. As far as I know, there's no indication it's ever been used in an individual case where the FISC court says, can you look at this application? And what we know is that when we actually put those applications under a spotlight, which is relatively rare, as the chair mentioned, out of, I think, 29 cases reviewed, 25 of them were in error. So there's obviously a need for some additional viewpoint. I don't think that's going to be achieved with any amicus curiae. I think that what you really need is this sort of concept of a special advocate, a formal office that has the ability, among other things, to bring a case to the appellate FISA court, to say that there's a problem here that you should reveal or review. I think that would be very useful to have an actual privacy advocate with security advocacy. If you're going to have a secret court, let's make sure both are represented.
Thank you, Professor Turley. And Mr. Chairman, I yield back.
Thank you. Chair recognizes the gentleman from South Carolina, Mr. Fry. Thank you, Mr. Chairman. You know, this is incredible. I mean, we finally, we've been fighting all week on the floor on the NDAA, and in this committee, it's always a knife fight, it seems like. But in today's hearing, we have really unanimous support for fixing this process. We're letting it expire, but there's a recognition across the entire country that this needs to be fixed. You know, what's perplexing to me, and we just had Director Ray come in, Professor Turley, you alluded to that earlier, who, if you ask agencies, all is well in the land of Oz, and that's just really not the case. We know that the FBI and other agencies have abused FISA to the nth degree. We know that they continually spy on Americans without a warrant. We know that they end around and they use data collection and geotagging and geolocation to look at the activities of Americans. And at the end of the day, you know, I look back and Professor, you cited the Federalist Papers. You know, we're a nation of laws. We're not some Orwellian dystopia where these things are appropriate or even allowed, but we've allowed them to happen. And I think to the point of the entire panel, we really need to get a handle on this in a pretty aggressive way. Professor Turley, I want to start with you. To hear the FBI talk about it, we should be celebrating that we went from 2 million illegal search queries to 200,000. Do you think this is cause for celebration?
No, it's like a bank robber saying we're hitting smaller banks. I mean, the problem is that you're engaged in something you're not supposed to do. Look, the thing that we have to keep in mind is that all governments are information junkies. That is consistent across all types of government, whether they are democratic or authoritarian, they're information junkies. They want more information. It's not necessarily for nefarious purposes. It's that they want data. They always do. And so this impulse will exist and it will grow unless you restrain it. I was baffled by the director's testimony. When he said that he wasn't even aware of what parallel construction was, I was really taken aback, because that's a core issue in these FISA debates. It's been an issue for years. And I just looked in disbelief when he said, I'm not sure what that might be. What that might be is a very serious threat to privacy that's existed for years. It essentially replants material in order to create a different origin. And its purpose is to hide the original origin from courts. And as someone who's litigated national security cases, I have to tell you that these cases are riddled with this type of sleight of hand. And I'm usually the cleared attorney in national security cases. I've had national espionage, terrorism cases. And when you hit a FISA line, all the lights go off. I mean, the government gives you nothing. But the other thing that I want to emphasize about these commercially available information is it has another insidious problem. And that is, what happens is the government often wraps commercially available information into FISA applications, and then everything gets iron-plated under FISA. And when people like me finally see the applications in the SCIF, we find it's loaded with material that should have been disclosed to defense counsel or to trial counsel.
Right, so this is nothing to celebrate. I mean, 200,000 violations of the Fourth Amendment is not really a good cause for celebration. You know, Professor, I think you hit on having a special advocate and strengthening that. I think that's a great step. What in your mind are other reforms that would be crucial to fixing the FISA problem that we have in this country?
Well, Congressman, the most important one is where we should have started and ended this debate in '78. That is, you cannot engage in a query or search of a U.S. citizen without a warrant or Title I order, period. I don't think it should matter where that occurs. Now, it's true, the extraterritoriality of the Fourth Amendment has not been supported by the Supreme Court, but you can support it. You can support the rights of U.S. persons abroad. That creates a very clear line. When I talked about letting the provision sunset, I'm saying that when it sunsets, you make clear that all searches or inquiries, wherever they are, of a U.S. citizen by a U.S. agency must be accompanied by a warrant or Title I order,
right.
Period. And they can find a way to try to get around that, but that's the brightest of bright lines.
Mr. Chair, real briefly to wrap up, I'm also concerned that even if we fix this, that the administration, a future administration, would just end around this by virtue of executive orders. So how do we deal with FISA and reforming FISA when an administration could just go around it? What would you suggest in that sphere?
Gentleman's time has expired. You may answer the question.
I think the short answer is 2 words. Any statute needs to make clear that whatever Congress specifies as an appropriate search has to be the exclusive means of obtaining the information that's covered. And if you're a lawyer sitting at the White House or the Justice Department, you feel an obligation to be sure that the president that you serve takes care that the laws be faithfully executed. And if it's clear in the law that there's one exclusive way of getting the information at issue, you're going to feel some obligation to be sure that your boss proceeds in that way. But if there's a statutory vacuum, that's where the problems arise.
Gentleman's time has expired. Now, I haven't taken my 5 minutes of questioning yet, but I'm going to go ahead and do it. I'm going to limit it to, I think, 3 questions. And
I have the gavel.
you took the gavel from me. Yeah, she's good. She's going to pop me with that gavel. Okay, we're going to start with you, Mr. Turley, please. Let's get with this. Capacity of state and district courts to keep records and information sealed. That's one of the critiques we have about moving away from a FISA court because, oh boy, there'll be leaks as if there's been no leaks in the current scheme. So tell me your experience there, and is it possible for state and federal courts to keep information sealed?
Yeah, I always hear this objection, and it has no support at all. I deal with national security cases through regular Article III courts. All throughout the years, they have SCIFs, they have training, they're cleared. There aren't these allegations of leaks. The issue with the secret court is that no one's objecting that you can have a secret court in the sense of a giant SCIF where secret proceedings can occur. You can even have judges that are selected and trained for that purpose. The question is whether the standard for U.S. citizens and U.S. persons should be different in that courtroom. And I have never accepted that to be the case. I don't see an exception under the Fourth Amendment.
Right. I appreciate that, and I'm in agreement with that. Mr. Scher, I'm going to go to you next. The gentleman from Georgia kind of intimated that somehow data collection and querying is similar to an officer in a patrol car driving around and observing suspicious activity, maybe making a Terry stop, or whatever you want to call it. But how is this different, and why should we equate this more like to a wiretap rather than a stop and frisk?
I think it is very much more like a wiretap. I mean, yes, if you're a police officer, you have a right to be on a highway and watch what goes by, but that doesn't mean that you also get to have a helicopter flying over the neighborhood and taking pictures of everything that happens in every home in that neighborhood. And so, by all means, I think the wiretap analogy is the right one to use, because that exactly is what 702 is doing. Is it's taking a stream of data, a massive stream of data, and just pulling things out of it, and even if it's appropriate to collect the data, there need to be Fourth Amendment protections when it comes to searching that data, especially
just as you would have in a wiretap. I mean, when you narrow the search down, you've made it particularized. You've targeted somebody.
Right.
You're going forward and getting a warrant, right?
Right, and searching a database with somebody's name or other identifying information is more analogous to a wiretap.
And so I want to get to this other thing too, Ms. Goithin, and that is dealing with purchased information. And I think Professor Turley kind of got to it a little bit, is that they wrap it up. And when we've been briefed by the FBI on this, they talk about multiple databases that they're using, and then there's a wall that's created. Why should we prohibit the use of purchased material when we know other nations are using it?
Well, that's an important question. And let's be clear that we are talking about material that the government would need a warrant or a court order or a subpoena if it were compelling the production. So we're talking about sensitive information about U.S. persons. The reason the government can buy this from data brokers is because there are loopholes in the law. The law does prohibit phone companies and internet companies from selling this type of data to the government. But that law is from 1986, and so it doesn't address digital data brokers. They didn't exist back then. So there's this loophole where the companies cannot sell it to the government. They can sell it to data brokers. The data brokers turn around and sell the same information to the government at a handsome profit. So the information is laundered through a middleman. Now, we should be concerned about the fact that foreign governments can get this information. Congress absolutely should act on that problem, and the Brennan Center is in favor of comprehensive consumer data privacy legislation. That should not stop Congress from acting now to make sure that our government can't exploit this loophole. Because when the U.S. government is obtaining American sensitive information, there are risks and harms to American civil liberties that go beyond what can happen when private entities can get that information, or even foreign governments, because the United States government has coercive powers over American citizens that private companies and foreign governments do not have. The ability to put us in jail, the ability to deport people, to tax you, to fine you, to put you on a no-fly list, to withhold public benefits. There are all kinds of ways in which the government can impact our liberties. And for that reason, the Fourth Amendment applies to the U.S. government, not to private actors, not to other governments, and Congress should make sure that the U.S. government is honoring those Fourth Amendment protections.
Well, my time has expired, and I thank each one of you. You've provided us with some information, and I think is vital, a lot of comments. And what I would ask of you is, as we go forward, we may have ideas, legislation that we want you to review. Please make yourself available. We appreciate yourself making yourself available.
Mr. Chairman?
Yes, and I believe there's some unanimous consents?
Yes, there are. Yeah, I'd like, in tribute to Ms. Goteen, but I'd like to unanimously submit into the record Brennan Center Bipartisan Coalition responds to the FBI's new policies under Foreign Intelligence Surveillance Authority as unanimous consent, and under epic.org, July 13, 2023, new FBI procedures under FISA Section 702, out of touch with extent of abuse, gravity, and privacy threat. And I think I will yield on those two items as unanimous consent to submit
Without
them into the
objections, entered into the record.
At the collegiality that we will work together on the best solution of this matter. And Mr. Chairman, just want to put on the record, we are facing in the next decade artificial intelligence. And I yield back.
Thank you so much. And with that, I appreciate everyone being here, and we are adjourned.